Hi, I'm Ed Alexander, founder and attorney with Alexander Abramson, a business law firm in Central Florida. Question that always comes up when buyers have identified a business that they want to make an offer on is, how do you make that offer? Is it a letter of intent, or should you submit a binding contract to the seller? And so this recently came up with a gentleman, we're going to call him Jason, who was buying an equipment repair business. And this business repaired fleet industrial equipment. And so Jason submitted a pretty detailed letter of intent. He'd been a corporate executive and kind of understood that process. So he put together a detailed letter of intent. And the broker had actually suggested that he submit the contract instead of a letter of intent, and that he use the quote unquote standard contract of the broker. So when we look at letters of intent, right, what are the issues you get with a letter of intent? First off, letters of intent are non-binding as to the terms of the transaction. So they lay out the intent of the parties as to the purchase price, as to the payment terms, things of that nature. But the idea behind them is to get some level of agreement between buyer and seller so that the buyer can move forward with a due diligence review. So to protect both the buyer and the seller, there are usually a few provisions that are binding. The first provision that is binding is, of course, the due diligence provision. And it gives the buyer, prospective buyer, an opportunity, a time period in which they can go in and review the books, records, and other information about the business. By the way, it usually doesn't include interviewing employees. And then it also requires the seller to cooperate with that, and then keeps that information confidential. So there's a confidentiality provision. And then to protect the buyer who's investing time and money in doing this, there's also usually a no shop clause. And that no shop clause prevents the buyer from accepting any offers from any third party during the time that the letter of intent is in effect. So basically, the letter of intent is an opportunity for a look-see. The benefit to the buyer is that it doesn't require a lot of work upfront to make sure that the deal terms are all laid out in the contract, only to find out that the deal never goes through. The other part of that is, though, from a seller perspective, the seller doesn't really feel like they got the deal done. And so from that perspective, it is a little bit less acceptable. From the broker's perspective, the broker definitely wants to get that contract, because then the sale is pending. Now, if you decide to move to a contract, it's important to remember that usually you move to a contract, you don't have a letter of intent when it's a smaller, what we call Main Street deal. So it would be less than $1 million, less than $1.5 million. And then if you get into that higher deal, then you're probably going to go with a letter of intent. But even in those Main Street deals, if, for example, there are some complicated issues in the deal, then it's probably best to go to the letter of intent until you can define what the parameters of those complicated issues are. Now, from a contract perspective, oftentimes the broker will say, hey, go ahead, sign our standard contract. Unfortunately, there is no standard contract in reality, right? There are contracts that are promulgated by associations that have probably 80% of the terms, maybe even 90% of the terms that might be right. But usually the buyer is going to want an addendum to that contract that overlays the particulars of their deal on that contract. So you can use the standard contract, but you add on an addendum to that contract to make it reflect the deal terms that you have. Now, the good thing for the buyer is that once you have that contract in place, it's a done deal. You're moving forward. The bad part about it, and there's a few bad things, obviously, one, you're spending some money to get that addendum done. Number two, if you want to make changes to that contract, you really need to have a reason behind it. And that reason usually is coming from the due diligence review. So it's best not to go into that deal with a contract that doesn't reflect the terms and then expect that you and the buyer are going to be able to amend the contract to reflect those terms. Now, the other side of that is, if you're the buyer and you're going to a contract and you're doing a due diligence review, you've got to be right on top of those timing considerations. Because if you miss the timing consideration, then typically you'll lose your deposit on the deal. So this obviously is a complicated issue. If we can be of help in this issue, please give us a call. Our number is down below. And of course, definitely go to our website. We've got tons of resources on buying a business. Thank you. Talk to you soon.